Welcome to the Ada K Show. I'm your host, Ada K, and I am a criminal justice major. I am also a deaf courtroom commentator, breaking down the gripping courtroom drama while providing full ASL interpretation, making justice accessible to everyone. Grab a cup of Java and let's dive in. And don't forget, comment, like, and subscribe. And if you love this channel, please become a member. Well, hello, everybody. Take two. And I think we got the problem fixed. I don't know. God help us. We will figure this thing out. My bangs are doing whatever they're doing. Okay, we are going through the transcript of the Karen Reed files that has recently been released. And in those transcripts are also all of the sidebars, y'all. Yes, we got sidebar. Hi, Kristen for Toronto. Hey, babe, I'm sorry. I am struggling to see everything. My format has to be different tonight because we're going to read the transcript sidebars only tonight. This is just dropped. We are one of the first who are going to be going through this. Now, mind you, there are 7, 8, 9, 10, 11, 12, 13, 14, 14B, 15, 16, 17, 18, 19, 20, A, B, C, D. 23 of these documents I've gone through today. I am breaking down all of the sidebars. With that, we're not going to go through all 23 tonight because I have words that are basically 89,000 words. Yeah, I've done it. I got them all there, but we're not going to go through them all tonight. So I attempted this earlier. Today's been a day of hell. I'll be honest with you. I spilled coffee on my keyboard. I had to buy a new keyboard. I had to drive to San Antonio where I live. That's an hour away. One way. Spent 15 minutes purchasing this thing and drove an hour home and then finished all this work. So it's been a cray day. I went live a minute ago and everything was wigging out, including me. I am human. I am human. Hear me roar. Yeah, I roared a couple of F-bombs. I did. I was so mad, y'all. We're back. Okay, let's get into it. Okay, sidebar number 1. This is day 9. 7 and 8 has been released, but those are my glitchy ones. And days 1 through 6 have not been released. So let's go. Okay, let me go through here. Okay, sidebar. Maybe I should just do this. The court. All right, so what are we looking at? You said exhibit 379. Jackson said, yes. Little. It's pre-marked and stipulated, Your Honor. Court, I know. I just want to know what this is, Jackson. So I expect there's going to be some I got to get my mouse in the right place. Sorry. Different versions throughout the trial. The top is the dash cam from Saraf, which he already testified to. The bottom is the dash cam from Good, which he will testify to. And Saraf indicated was consistent with Good's vehicle pulling up behind him, and they've been scrutinized. The court. All right, I don't want you telling the jury all of this. Just show what's up there and ask him what he sees, not this big, long preface of what it is. Snippy much? Yeah. Mr. Jackson, can I orient him that they are two different dash cams? The court. You can say that. The Seraph dash cam. Jackson, if the court is satisfied, court, show it without comments. Jackson, that's fine. That's fine. Okay. So I want to talk about this a little bit. So what's happening here? Exhibit 3. I'm just going to bring this back and forth because I can't do it that way. Exhibit number 379 is a side-by-side synchronized video. The top one is Seraph's dash cam, already testified to, and Good's dash cam will be testified to. Now, Jackson explains at sidebar the video is synchronized, and Seraph has said Good's car pulled up behind him and was consistent with what he saw. He wants to present this side by side to the jury. The judge's limitations. The judge stopped him from pre-narrating and arguing the exhibit to the jury. She does not want long explanation, commentary, or mini closing before it's even evidence. She tells him he can identify it simply as Seraph's dash cam and Good's dash cam, and then show it without comments. Now, Jackson agrees. So the key point is the judge is policing how the video is introduced. Minimal description, no argument, no narrative and framing. Now, the sidebar number 2, we're going to continue. Okay, so here is Mr. Jackson. Until we pause it, I'm going to ask you to focus your attention on the top of dash cam video, whereupon the video was put up. Mr. Jackson, can you pause it? The court. Actually, I need counsel at sidebar, whereupon the sidebar conference was continued. The court. All right. There is one exhibit. It's complication. It's man-made exhibit, right, Mr. Jackson? Yes. The court. So I'm not sure I want to let all of these man-made exhibits like this in. I'm understanding that there are 600 exhibits and there's probably 100 exhibits of snow. There's a lot of things that I have not seen. So just because you all agree doesn't mean that things are permitted as exhibits, okay? So you're asking him to focus on the top, but you're still pointing to the bottom. What is the purpose of doing this? Y'all, she's getting there, isn't she? Mr. Jackson. Once the bottom exhibit, which is synchronized with the top one, once he makes his way to the stand, I'm going to ask a couple of questions about the bottom and whether or not he recognizes the individuals only. And the court, well, pointing to the top and asking him to focus on the top. Jackson, I am asking him to focus on the top first. Then I will ask him to refocus on the bottom as the video continues to play. The court. We will do this once. If I need to take a break, I will need to see all of the man-made exhibits. If this was not favorable to the defense and the Commonwealth wanted to do it, you'd move to keep it out. I would keep it out. So I just need to see it. It may break the rhythm. Do you plan to do more than just this during the cross of this witness? Jackson, no. I'm going 1 minute video. That's all. The court, I'm going to watch this. I just be very careful about the commenting. Jackson, sure. The court, I'd love to have seen these things earlier, Jackson. We can make it a habit of showing them. I have no problem with that. Little. We provided them to the Commonwealth and they stipulated to them. Court, I still need to let them into evidence. This evidence not typically done. So again, if it has been harmful to the defendant, the Commonwealth tried to do it. Even if you agree, the gatekeeper, I would keep it out. Jackson, understood. Court, okay, so go ahead and do it on this one, but we're not going to need to break to see them before any other put together complications. Yeah, it is complications. Is put in. Jackson understood. Whereupon the sidebar conference is closed. However, folks, we're going to take a 15-minute recess. Court counsel, I just need to see you both. And they were sidebar conference now follows. And there is redaction after redaction. The court, so something like this happens, it will sort of be abrupt recess. Jackson, keep everybody court. Yes, I just opened the door so people can go out. Okay, court. Why didn't I watch this? How long is this? 3 minutes? Why don't I watch this now? Court reporter, closer, please. Yeah, I can imagine the court reporter, closer, please. You need to come close, Jackson. I was reminded. I'm happy to play the 3 minutes. This has already been not this particular video, but we have synchronized videos, I think, already with Good and Seraph's video. The court reporter, one at a time, counsel. The court. And Miss Little, I appreciate it if Lally is questioning the witnesses. You can't object. Okay. Court, you can certainly reach over and tell him to object, but you can't object. Okay. Just as Mr. Jackson's witness, I'd like to see this. Mr. Jackson, sure. Court, will ask the witness to step out. So the witness leaves. Mr. Jackson, that is the extent or approximately the extent of the length of the video, the clip that I was going to play. Court, okay, we'll take a 10-minute recess. Jackson, thank you, Your Honor. Where a brief recess was taken, court resumed, defendant present. Okay. Court, this is a long one, y'all. Remember, I think this is that really, really long one. The court, all right. I noticed that it was about 6 minutes and something up there. The two of them. The witness testified to 1 minute conversation. You're going to show 3 minute snippet? Do you have pre-marked exhibits? That doesn't mean that they are in evidence. Do you still have to introduce those into evidence? So you have to lay a foundation before you can say, I'm going to show you this and where in this did the conversation take place. He has to acknowledge that it did take place in there. And if it doesn't, it's not coming in. Jackson, I'll lay the foundation. Court, okay. So you need to, but there was a confusion about you pre-marked 600 exhibits. The hell? That doesn't mean they're all in. So far, there are maybe 15 exhibits and evidence. Why is she focused on the 600 when they're talking about this one clip that is a dual video? I don't understand where she's going. Your Honor, may I talk with Mr. You can go ahead and talk. Let's save time. What do you want to say? No, I just wanted him to relate something to the court with regard to Sheriff. That is in evidence. With regards to Good, the video will be in evidence. But it's not now. I understand, Lally. And it won't be until I let it in. Do you understand? I'm going to go Canoni. It's easier than court. Lally, I completely understand. My request to Mr. Jackson would be that it would be admitted, been given that we fully expect it will be admitted. Goodwill. Canoni, we're not going to do that with 600 exhibits. Oh, Lally, no. Canoni, but for ease of doing this today, they may both be in. But if a witness does not acknowledge it occurred anyway on that before you ask him compound question, it's not really clear what his answer is. You need to lay the foundation to get it in now, Jackson. All right. Sidebar concluded. Well, Okay. So I want to talk about this. After the video goes up, Jackson asks a witness to focus on the top portion. Okay. The judge calls another sidebar. She recognizes that one exhibit, but it is man-made complication. It is not just a raw evidence, it's edited and synchronized presentation. Just because you all agree doesn't mean things are permitted as exhibits. So she's saying, you can agree, but I have to permit it in. She reminds them that she has not seen the majority or the most of the 600 pre-marked exhibits. I think Cononi is having a coronary over the thought of 600 exhibits. And she is very explicit. If this weren't favorable to the defense and the Commonwealth wanted to do it, you'd move to keep it out and I'd keep it out. She's basically reminding him, if the other side was doing this, you would object and I would sustain it. That's a huge line. What she's saying is these kinds of complications are not typical evidence, and they're not. And she would likely exclude them if they were being used against the defendants. Now, Jackson's explanation says that the top video is Saraf, the bottom is good. He will later ask the witness about the bottom portion, identifying the individuals. But for now, he's directing the focus to the top video. The judge's practical concern is that he's pointing out the bottom video while telling him to focus at the top. She wants clarity and no confusion for the record. So the judge ruled that she would allow a 1 3-minute video with this witness, but she is going to watch it herself. She will require a break before any other put together complication is used in the future. And she warns Jackson, be very careful about commenting. Again, she repeats, gatekeeper. She would keep the exhibits out if they were unfavorable to the defendant and used by the Commonwealth. Underscores how cautious she is being. Now, Jackson and Little both accept Little notes they already are given them to the Commonwealth and have stipulations. But the judge reminds them that stipulations do not automatically mean accessibility. So the third sidebar, logics, other trial neighboring courtrooms and who made objections. Okay, so are we on 63 now? What are we on? Okay. The judge explains there are other jury trials in the first courtroom when the jury moves doors and open corrupt. Okay. I think did we read that? I think we did. They're to move and roll a description. She wants to watch the clip. The court reporter asks counsels to speak up. When Lolly is questioning a witness, Little cannot object directly. So that is a key. If you got one attorney who is the lead, who is questioning a witness, another attorney cannot object on their behalf. They can nudge them and go, objection. They can hand a note that says objection, but they cannot object. One attorney, one witness. No other attorney can intervene, and that's what she's talking about. She then clears the witness from the courtroom. Now, Jackson confirms that this extent of the clip I was going to play. Judge calls for another short recess. This segment mostly is logical and decorum management, plus confirming the length of content of the video. Then there's this fourth section of the sidebar that we just read, the foundation pre-marked exhibits and deeming admission. So now we are back after the recess, and the judge watched the video herself during said recess. So the judge's first concern is length in testimony. She notes that the video file shows 6 minutes plus in total. The witness testifies the conversation was about 1 minute. Jackson plans to show 3-minute snippet. The judge is worried about overbroad playing of the video, portions not tied to the actual testimony, and potential prejudice or confusion. The judge section concerns pre-marked and evidence. She is emphasizing Pre-marked exhibits like exhibit number 379 are not automatically in evidence. Only 15 exhibits are actually in evidence to this point. They still have to lay the foundation, move it in, and then get a ruling. Now, she tells Jackson before using complications as an exhibit, the witness must acknowledge the conversation appeared in the video and or it doesn't come in. So if the witness does not acknowledge a conversation in the video, it won't come in at all. It will not come in. Period. Now, Jackson says he will lay the foundation. Lowley's request, admit goods video debeing. Lawley says Seraph's video is already in evidence. Goody raw dash cam will eventually be in evidence. He asks that the good video as a part of the complication be admitted. Debeing, which basically is provisionally in a goodwill. Debeing or bene, depending on how you say it, where you're from, is provisionally. And then goodwill pending full foundation later. Now, Canoni's response, we're not going to do that with 600 exhibits. But she gives a narrow path. For today, both may end up in, but not without a proper foundation. If the witness does not acknowledge the conversation appears there, Jackson cannot proceed with the compound question based on it. And she tells Jackson plainly, lay the foundation now, then proceed. You shite and get off the horse. So how do I say this? This is procedurally rich and strategic significant cluster of rulings. Number one, it shows the judge is deeply cautious about the man-made video compilations. Thank you. Side-by-side synchronization of the clicks, argumentative by nature. She's willing to allow them, but only after she personally viewed them, only once, and a very limited commentary. Very, very limited commentary. Hold on. What? I don't know who he's talking about. Okay. So the stipulations, automatic accessibility, defense created them. No more pre-marked means in. Meaning the 600 pre-marked exhibits does not mean that all 600 exhibits will be in as evidence. Each one of the 600 must properly be sponsored, given the foundation, and formally admitted. She is balancing fairness as a role where revised. She's reportedly saying that, let me move this sideways, sorry. If the compilation were hurtful to the defense, the Commonwealth tried to use it, she would keep it out. So she's saying, fair game. I'm warning you. If this was you, this is what I would do. Okay? So we're going to now go to page 74. And we have sidebar. Where is it? All right. Is this helping y'all understand? Are y'all getting it? So y'all are talking about the game. Okay. Is that 49ers 34 Colts? Is that it? Is that the final? Okay. The court. What do you want to say, Mr. Lowley? Ooh, what a way to start it. Okay, can you think about that as an attorney walking up to the judge and you say, sidebar, please? All right. And you get up there and they go, what do you want to say, Mr. Lowley? Lowley, Your Honor. So I think counsel can direct the witness's attention to the particular part of we're still on the video, or a particular point on the screen and ask him if they know where this is or if they recognize what this is. But describing it to him and then asking him to confirm it, I think, is improper. So the testimony has to come from the witness, not from the counsel. Jackson, that is completely untrue. This is cross-examination. So I'm allowed to lead the witness. Yes, and I remember this. He is allowed to lead the witness. The court. You can lead the witness, but not on something that he is not adopting to all. You cannot narrate this video, and that's what you're doing. Jackson, I'm leading the witness. I'm asking him, does that appear to be you? Does that appear to be somebody else? And I will leave with the answer that there is. The court. And then you said this is a firefighter. It's a yellow jacket. So Commonwealth versus Please is an important case on the issue. You've got a video up. The video speaks for itself. A lot of what you're doing is improper. Your Honor, excuse me. But there's only been one objection, and I'm sustaining that objection. You can go back and do it properly. Ooh, snap. Someone's getting a little aggressive here. So let's talk about that sidebar. So Jackson is using the video and pointing out things on the screen, essentially telling the story. As he's questioning the witness, Lally objects. Lally is objective counsel narrating and not questioning. Counsel can direct a witness' attention to a part of the video or point on the screen. Ask if the witness recognizes or knows what that is. But what they cannot do is describe what's in the video first. Then ask the witness to confirm the description. Here's a good core point. The testimony has come from the witness, not from the counsel. He's objecting to improper narration and testifying through the question. Jackson's response is, this is cross. I can lead. Well, no, you can't. So in the end, he is overstepping his thing. Now, the Commonwealth versus Please. This is a case stands for the principle that when a video is in evidence, a video itself is evidence. A counsel may not overinterpret, add narrative, tell the jury what to see, especially where the witness hasn't agreed. You've got a video up. The video speaks for itself. A lot of what you're doing is improper. Now, that goes to the Commonwealth versus Please. The ruling objection sustained, redo properly. The judge notes that there only has been one objection. So, what does this mean? He can ask the witness what the witness sees. He can ask if he recognizes himself. He can ask, do you recognize anybody else? He can ask if he recognizes the location. He can lead the question by saying, there to be what the witness is willing to adopt. So he cannot do is provide his own labeling, identifying labels. He can't identify people himself or the story for what is shown, and then force the witness into a yes or no narrative. So he cannot sit there and say, that guy wearing the fire jacket, is that a firefighter? No, he can say, who is that person in the video? Well, he's wearing a firefighter jacket. I assume he's a firefighter. I believe, or he is. Do you know what the name of that firefighter is? No, I do not know. Or yes, I know exactly who that is. That is what he can do. That is leading. But he cannot sit there and describe the person and get him into a yes or no. So, let me scroll down and see if we got any more in the near future. I got to shrink this down to here because I don't have a proper page number for the next one. So we're going to scroll through. Gotta hope it lines up. We're going to do this for a little bit, but this whole series is going to be done in bits and parts. Oh, snap. We're probably missing a few. Let me get it back up to, there we go. I have to make it smaller to see the whole page to see if I miss, because sometimes I've missed it doing the other way. So here we go. Here we go. Here we go. Okay. Okay, Your Honor. I just wanted to flag for court and to minimize the interruptions here towards the end of my cross-examination, which I don't think will be lengthy anyway, but I intend to refer to the video, which I am not sure is in evidence. It is in widescreen version of Seraph's video, which has been pre-marked. I'd like to offer it into evidence, given that I believe the foundation was already laid through Officer Seraph. Court, okay, Yannetti. And then I'd have the witness refer to it. I'm playing a 15-second portion of that video. That is it. The court, okay. Any objections? No. Okay, thank you. Why did we have a sidebar? Well, basically what's happening is when a defendant flags an issue, it avoids interruptions. He's being proactive and professional. He doesn't want to surprise the judge, and he doesn't want to disrupt the flow of the cross. He wants to make sure that the video is properly admitted before using it to avoid the crap that we just faced with with Jackson. He is hedging his bets is what he's doing. 136. Okay, here's the next side. Mr. Yannetti, I don't want to overstep my bounds, but I'd like to play. Oh, wait a minute. Yep, that's right. Overstep my bounds. I'd like to play the video one more time, just for the purpose of directing him more towards the beginning of the video, which it is before the statement that he said. And my argument, the court, for what purpose, Yannetti? Just to see if he can. I heard it. I think other people heard it, court. But it doesn't matter. But doesn't what matter is whether the jury hears it? Yannetti, correct. So that's the law, correct? Now, right here, she corrected him and she's helping him right here. If I was a judge, so you're wanting to replay it so other people can hear it. Yeah. Nope, we're not going to do it. She's handing it on to, she's helping him here. And she is literally helping him here. She's directing him to correct his answer to, instead of other people, but to the jury. And the judge, so that's the law, correct? Oh, for sure, for sure. But the testimony right now, if I can get the witness to acknowledge that, I think that will assist the jury. Oh, I got you, Your Honor. I'm on the page. Let's go, Your Honor. Okay, we're good. I got it. So I think that will assist the jury. And I don't think there is any, I'm not looking to unnecessarily delay the trial. I'm looking for about 10 seconds. The court, nope, play it again and just ask him if he heard that. Thank you. Thank you, the court. Don't ask him whether he heard. Just say, what did you hear? Good. Thank you. Conference concluded. I'm trying to read. I want to see what it was. I heard someone say, fucking dead. Thank you, sir. Any redirect? Just briefly, Your Honor. Oh, that was good. He didn't hear it. He just said, fucking dead. Woo! Okay, so let's talk about that. Oh, this court case was a doozy. Now, this is the first trial, okay? This is the one that was hung up in a hung jury. So he wanted to play the 10 seconds from the beginning of the video again. He believes he heard something in the clips and he wanted the witness to acknowledge it. I don't want to overstep my bounds. He's trying to avoid improper commentary or narration, and he's covering his butt with the judge. Now, the judge immediately asks key evidentiary question for what purpose? The judge is testing. Is this for impeachment? Is this for clarification? Is this cumulative? Is this proper use of the video evidence? What are you asking? And then the judge reminds him the core rule: the jury must hear it. Does it matter whether the jury hears it? Absolutely. This is a foundational rule. If the jury can hear it themselves, the witness interpretation is not evidence. The recording itself is the evidence. So as long as the jury can hear it, we're good to go. Now, the same principle behind it, the video speaks for itself. The audio speaks for itself. Counsel cannot narrate. And he's being careful because he just nailed Jackson, and so did the judge on this earlier. Now, the defense agrees with the law, but explains the purpose. Now, Yannetti says, yes, the jury hearing it is what matters, but he wants the witness to acknowledge what is heard. He believes it will help the jury understand the clip. He emphasizes it is not a delay of trial. Now, once again, play it again, but just ask him, did he hear that? But then immediately corrects himself. But don't ask him what she does. Immediately corrects herself. Don't ask him whether he heard. Just say, what did you hear? Which is exactly what should have happened. Now, this is a critical distinction. What is not allowed? Did you hear X? Did you hear him say X? Isn't it true he said X? That's leading. What you can say is, what did you hear? This is what consent leaves the answer open, avoids putting the words in the witness's mouth, avoids narrating the video, and keeps testimony clean. The defense accepted the ruling. Everything's fine. So why was this sidebar important? It reinforces the rule of recording not the witness, but the evidence in itself. The judge is protecting the jury's role, the integrity of the evidence, and the fairness. It prevents improper narration. The judge is consistent with the earlier rulings, and lawyers cannot narrate a video. Lawyers cannot tell the jury what should be heard or what they think is heard. The lawyer cannot put words in the witness' mouth. This ensures witness testimony is genuine and not coached. By requiring, what did you hear? The judge ensures the witness answer is authentic and not confirming the counsel's narrative. It protects the records also for appeal. It also protects for the appellate court. So that is important. Okay. I'm trying to find, I thought they went into sidebar. I think we need 2 hour view. Don't think that long. Man, worry, ordering lunch and things. Okay. All right, let's read this. Mr. Lally, the judge, the court, I have mundane things to worry. All right, 10:30. I think it's about a 2 hour view, Lally. I don't even think it's that long. Court, I have mundane things to worry about, ordering lunch and things like that. But, see, this is stuff we did not get to hear. We did not get to hear any of this stuff. Okay, sorry. I had to read something from my notes from my mods. No, Lally, no, I understand. But I mean, for me, no. I mean, from Denham to Canton on the scene, probably 10 minutes at most, 15 minutes. I mean, I don't know why the court. Then why is it going to be 2 hours? Lally, I'm sorry. The court. Then why is it going to be 2 hours? I didn't know that it was court. I was told it was 2-hour view. Lolly, no. Jackson, that wasn't from us. Yannetti, that would be max. I think it's going to be shorter than that, Lolly. 10 minutes might be a little, because the vehicle will be there as well, which we need to address. But I think we can probably do max an hour and a half, like on the bus, where's bus there and back. I think we should be able to do that court. Yes, Jackson, I agree. Okay. Who's your witness for tomorrow, Lally? So I think it'll be Miss McLaughlin. We're talking about the witnesses. Don't need to worry about that. Okay, sidebar concluded. Not a big deal on that. They're just explaining the need for scheduling clarity. So we're good with that. Let's go to the next sidebar. And it may take me a minute to pull it. I may have to switch documents. Let me see. Yep, I got to switch documents. So let me scroll up to 10. What happened was earlier, and I got real frustrated, was that all of my pages, I had everything in number order, and when it saved, it saved everything out of order. So it has been a little difficult for me to find everything, but we got some of them figured out. So we're only going to be live for about an hour or two today, with between an hour and 2 hours. And I'm going to be doing this in pieces because there's so much here, y'all. And page 10 has got a lot. Day 10 had a ton of sidebars. I kid you not. So I have to scroll and get to my 1035, 34. I'm getting there. Give me a second. Man, day 10 had a lot of objections. And I mean a lot. Like within the first minute, there was an objection. I don't even court was in. I think there was a sidebar even before the day began. I kid you not. Even before the day began. Let me get to, okay. So let me pull up document number 10. And put the page number in. Let's do 7. Here we go. I'd like to see counsel a sidebar for a brief moment. If they could bring Miss McLaughlin, please. The court, good morning. Come closer to the microphone, please. So, a few things. I was given copies, I think, of exhibits 26 through 379 from the defense this morning. Do those contain all the videos you intend to introduce into evidence? Miss Little, I provided the court with copies of the ones that we had put aside by side. Okay, I want all the ones that you intend to introduce. I don't want surprises like this. So, I know you can't get them today. That's what. I thought it was clear. I wanted to spend the time this week reviewing them. Miss Little, you wanted all of our exhibits for the rest of the trial? The video ones, the ones that you of the side by side? Whether you're playing for the jury or not, the print ones. I'm not concerned about print ones. Anything that's video. Anything that's video. Little, I believe the Commonwealth already admitted the rest of the just regular dash cam videos. So there's nothing really in evidence, and that's a part of what I'll talk about for a minute as well. Mr. Lowley, I would like at least the corresponding Commonwealth dash cam videos that the Commonwealth has, the original dash cam videos that the Commonwealth has introduced. That's one. The second thing, is yesterday, Mr. Jackson, you referred to the court reporter as Nancy. We are much more formal than that here generally. But my big concern is I've known Madam Court Reporter for 35 years, and I've never called her by her name, particularly in a case where people's personal information has been put out on the internet. I cannot allow it, all right? I don't think you mean anything by it, Mr. Jackson. I certainly did. I'm not saying that you did, but we have to be extra careful about that. Third thing, please come to sidebar before any videos are played that I have not seen. Okay. Sure, court. That has been going on with the exhibits. I know you've pre-marked a ton of exhibits, and I know Madam Court Reporter has been here all day marking exhibits, close to 600. It is too sloppy. We're going back to the old-fashioned way. Yesterday, the exhibits were available for the press on Tuesday and Thursday afternoon. That was a wonderful person from the clerk's office here that is doing that, had a good sense to send it to me beforehand. And the exhibit number 140, the fire department report, when I reviewed it, I didn't see the exhibit. Originally, the exhibits are introduced into evidence. I didn't get to see it. I have a copy of it. They're supposed to be held by the clerk and held overnight. I don't know where these exhibits are. And if there are 600 of them, they all need to be here. So we're going back to the old-fashioned way, because on paper 1 of 5 of what's being marked in Exhibit 160, we're going to mark this identification for these purposes. The court reporter, that will be G for identification, Your Honor. Whereupon incident report, previously exhibit number 160, is entered into marked exhibit G for identification. The court, pages 1 through 5 of all of John O'Keefe's personal identifying information that could have been on the front page of the Globe today. Miss Little, it's not our exhibit. Court, it's got to be redacted. All exhibits have to be redacted before they are admitted into evidence. It may take half a day, and we'll break early if you need to do that, but they have to be cleared. In the case that does not have press interest, we let people do it maybe later that day or the next, but it has to be cleared. This never should have happened, Mr. Lally. Yes. The court, it is not going to happen, all right? So pre-marking exhibits is out. We are going to do it the old-fashioned way. If you're in agreement with an exhibit, I still need to see them before they come in. Molly, sure. The court, you don't need to go authenticate everything if you're in agreement. It's obvious. Got it. And I don't need 100 pictures of snow. I'm just saying. All right. The jurors aren't going to look at 600 exhibits. I can't imagine they won't. All right. So let's just move the case along. I'm not interfering with how you try the case, but I do have a role here, and these are important. All right. I was supposed to be gone. I'm glad I was still here. This could have just gone out. Okay. Jackson, please apologize to Madam Court Reporter. I certainly meant no offense. Nobody thinks you meant it, and I think it was just underscores of the point that the less necessary chatter, even during questions, the better. Right. There's less of a chance that this could just ask a question, no comment, even CPR. You're not being certified except as blank. We are not used to that here. Jackson, right. Court, and I really don't want it. Right. Jackson, court, there is less chance of a problem. Jackson, okay. Court, all right. Thank you. Okay. We'll bring in the witness. Y'all, that's insane. So we're going to break that down a little bit. A lot to break down, but we're going to break down. I'm going to try and keep it as short as possible. Judge demands all exhibits to be advanced in advance. The judge provides Exhibit 26 and 379 that morning. She wants all videos the defense intended to play, but does not want surprises. She expects to review them over the weekend. Defense must provide every video they intend to use. It includes a side-by-side comparison. The legal significance in this is it prevents surprise evidence, unviewed enhancement, potential mistrial issues, and claims of unfairness. She also orders the Commonwealth to provide the dash cam or video, the original, again, for authenticity, completeness, and proper foundation. The judge reprimanded Jackson for calling the court clerk Nancy. This is not out of disrespect, but safety. The judge does explain that she has known the court reporter for 35 years, never used her name. This case involves doxing, harassment, and personal information being posted online. Using her name in open court could expose her to danger. The legal significance is it's protecting the staff, maintaining formality, and preventing personal information from being used in public records. Let me skim through. The judge is still upset about these 600 exhibits were pre-marked. She has not seen them. They are not being held by the clerk as required. So they have all this, they have a list of the evidence, and they are popping the evidence out of thin air when they should be in the possession of the clerk. Yep, they're required to be the keepers of the evidence. She discovered Exhibit 140, a fire department report contained John O'Keefe's personal identifying information that was released to the press. That is a huge no-no. This could have been published by the press. Pre-marking is banned. Exhibits will be marked one at a time, and the judge wants every exhibit before it's admitted, and everything must be redacted. The exhibits must be fully redacted. The court will break early if need be to allow that to happen, and it must be done that day. In the future, this will never happen again, right? Judge has ordered no pre-marking, which we already talked about. She's also worried about the parties' need to authenticate the uncontested exhibits. She does not want 100 pictures of snow. Why? It's overloading. The jury is confusing. It's prejudicial. It's irrelevant, and it sucks. The judge tells Jackson, less chatter, unnecessary comments, no informal remarks, just questions to prevent misinterpretation, improper influence of the jury, distractions, and risk of mistrial. Then she goes on, the judge, so we've talked about I'm kind of skimming because this was a big, long document. I told y'all this is going to be a lot today. Okay, do you know who her family is? Mr. Lally, objection. Court sustained. Mr. Jackson, may we approach, Your Honor? Court, yes. So, court, what's the objection? Relevance. The court, how do you respond to that, Jackson? The witness has a deep friendship with Caitlin Albert. She knows the Albert family. We have photographs of her traveling with Caitlin Albert, going to the beach with Caitlin Albert, how old are these photographs? Jackson, I'd say probably they are adults. She's only in her mid-20s or so. I won't ask her age, but they can't be more than a couple of years old, 2 or 3 years old, I would guess. They have several social media accounts with their friends, tag each other, the vacation together, they drink together, they socialize together. She is diminishing the relationship between Caitlin Albert and her knowledge of the Albert family. I think she knows the Albert family. I know she knows the Albert family, and she knows where the important 34 Fairview Road is. I don't believe it's the first time she's ever even been to 34 Fairview, court. So you can focus on that. The other is too extreme. It's not relevant. It's certainly not probative. Jackson, that she knows the family or the house. You say it's relevant to the house. Her being at the house. She knows the family. She knows the house. You can do that. Social media, traveling together. Is Caitlin Albert going to testify? Lally. Yes. Court. She was just one of the people at the house that night. Correct. She is also at the Waterford bar that night. Court. Jackson, she was also at the Waterfall bar that night. Court. Yes, but it's not probative. If any relevance, there is a little bit of a stretch too. But I'll let you get into she knows her and she's been to that home before. Mr. Jackson, just so we don't have approach a sidebar again, I got photographs of them together. May I mark those? You can mark them for identification. Jackson, and show them to her? The court, no. Lally, Your Honor, for the reason I have never seen these, I don't even know what counsel's talking about as far as the photographs and social media. Jackson, but because it's impeachment. But if you knew you were going to use it, you have an obligation. Jackson, I didn't know. Court, hold on. Whereupon there was a pause at the sidebar. Jurors, we're going to send you out. Mr. Court Officer, 10 minutes. It resumes. Show them the photographs and we'll have a short voir dire. We'll come back out in 5 minutes, whereupon the sidebar conference concluded. The court, Miss Laughlin, I'm going to step out for a minute. Show them what you have and let the court officer know when you're ready. Court. All right. So, Mr. Jackson, let's mark the identification items you told us about at sidebar. Jackson. The first one would be do you want me to describe them for the record, Your Honor? No. Just say so. No. So they are not to be put up on the screen. These are 4 items. One of them, court, don't describe them. I need to see them. So let's bring them up and mark them for identification, Madam Clerk. Then we will give them back, but I need to mark them for identification. I need to see them. So we will mark them first. My God, what is up with this? What is up with this about her being so freaking... This is a problem when you have a lawyer halfway across the country that has been given permission to try a case in a county and jurisdiction that he's never been in. And some rules do not apply. Some judges do things differently from the East Coast to the West Coast. I get it. But my God, this should be lawyering 101, judge 101. Why is this such a big problem? All right, back to it I go. So we will mark them first, whereupon the photographs were entered and marked into Exhibit 8 through the including K for the identification. The court reporter. That will believe H through K for identification. Court. All right. So we have 4 pieces of paper marked for identification that appear. You've got these off of social media sites, Mr. Jackson. Mr. Jackson. Correct. That's correct. Court. Okay. When did you get these, Mr. Jackson? I couldn't tell you the exact date, but we've only roughly had them between 6 months to a year. The court. Okay. Commonwealth. You've not seen these before? No, Your Honor. All right. So we'll talk about that. Rule 14 a little bit, but we will bring the witness in. You can ask her the question. Mr. Jackson, about her vacation. You mentioned her and the drinking that you talked about, the relationship with the Alberts. I've forgotten her first name already. Caitlin. Oh, court. Caitlin. And about the house. So you can ask her the questions about that. You can show her these exhibits or these marked for identifications if you need to. You may have trouble actually getting those in evidence, but I'm going to let you find out. Wow. That's interesting. Oh, thank you for lurking. Is it Crystal Hines? I don't have my glasses. They're broke, so you're that small. The print I'm reading is this big. I know, right? Thank you for lurking. You can ask her to identify them, how long ago they were, and things like that. Thank you, Mr. Jack. Court, could we bring Miss McLaughlin, please? Jackson, may approach? Oh, yes, in the Commonwealth. Well, you just saw these today. Yes, I did. And you objected at sidebar that these come in? Correct. Okay, court. Mr. Jackson, here is the last one. So, Miss McLaughlin, Mr. Jackson is going to be allowed to ask you questions outside of the presence of the jury, and you are still under oath, and you have to answer truthfully, okay? Whew. Y'all, these were spicy, as my daughter would have said at the age of 5. So, this multi-stage sidebar includes initial relevance objection, a recess, a voir dire outside the jury's presence, marking exhibits for identification, a Rule 14 discovery warning, and the judge ruling on what Jackson may ask. Here's my quick legal breakdown. Well, I haven't had dinner. I have a half a hot dog over there. That was my lunch. Okay, this sidebar centers on whether Jackson can use social media photographs to impeach a witness by showing that 1, she was a close friend with Caitlin Albert, 2, that she had been to 34 Fairview before, and 3, that the Albert family, she knew them far better than she had exclaimed. The prosecution objection on relevance. Well, let's break that down a little bit, okay? Relevance. He argues a photo and social media evidence do not relate to any facts in dispute. Jackson argues evidence shows witnesses minimizing her relationship. The witness is downplaying her relationship with Caitlin Albert. 4, they have 1, traveled together, 2, vacation together, 3, drank together, 4, socialized together, and 5, tagged each other in multiple social media accounts. The photos were recent, 2 to 3 years old, and this matters because she claimed she barely knew the Albert family. Jackson believed she knew them very well. She likely knew the significance of 34 Fairview and that she may have been there before. Thank you so much for the hearts. This is from trial 1, FYI. They haven't released the second trials yet. This is a classic impeachment. To show the witness is not being truthful about her relationship with key people. I do remember this, and I remember we went 8 nuts over this. In fact, this was a big heated discussion on my live during this particular part of the testimony. So what did the judge rule? That Jackson may ask whether she knew Caitlin Albert, whether she had been to 34 Fairview, and whether she knew the Albert family. Aww. Hey guys, don't forget to like, comment, and share, and subscribe, please. I appreciate it. And we do also offer memberships. Jackson may not ask about the vacation, drinking together, social media, and the traveling together, unless she opens the door. Now, if she goes, yeah, I recognize this. We took a vacay together. Boom, door open. He can ask about it. She allows only the core relevance. Did she know the family and the house? Jackson asked to mark the photographs. They were admitted into evidence. He says, I have never, then it goes back to Lally objects because he'd never seen the photos before. And he says, I've never seen any of these, and this triggers Rule 14 of the discovery issue. Jackson now claims the impeachment, so he did not have to disclose it. And that's true. That is where, hi. Oh, we're going to have a lot, but we're not going to cover 88,000 words in one night. This is going to be broken down. We're going to go over this a little bit at a time. So Jackson has a right to the impeachment. What happens is that he does not have to show impeachment evidence because then that can change the testimony because the defense can't. We had this actually happen where the prosecution found out that they were going to try to impeach their witness before they were done testifying for the prosecution. So when that was happening, they went back and tried to fix the testimony so it couldn't be impeached. And Jackson objected and it got really messy that day, y'all. So that was an interesting day. Now the judge pauses and sends the jury out. Okay, happy, June? The judge orders the voir dire outside the jury's presence, showing the photographs, and will have a short voir dire. So that means the judge will question the witnesses privately and determine the admissibility before the jury hears anything. This protects the record. The judge marks the photo for identification, reviews them herself, confirms they came from social media, and confirms the Commonwealth never received them. We will now, then she says, we'll talk about Rule 14 in a little bit. Rule 14 is a disclosure of certain evidence, even impeachment evidence, if it is extrinsic or not purely responsive. The judge is signaling that Jackson may have violated a discovery rule, but she will address it at a later time. Now, Jackson may ask the questions about the vacation, drinking, relationship with Caitlin, and 34 Fairview. He may show the photos only to the witness, not the jury. So he may show the witness the pictures saying, well, you said you didn't know them very well, but here you are drinking with them, on vacation with them. You're showing that you're in a relationship with them. You're at the Fairview home, and the witness can look at them and go, oh, shit, I'm in trouble. But they do not get shown to the jury. Now, you may have trouble actually getting those into evidence. What did that mean when the judge said that? Well, they may be allowed for impeachment, but not admitted as full exhibits. And that is fair enough. And that is the way it's been used for an impeachment. That's the only way it can be used without it being a Rule 14. So Lally maintains his objection. The judge tells the witness she is questioned outside the jury present, remained under oath, and she may answer truthfully. So why is this sidebar so important? This is a very unusual sidebar. It deals with the impeachment by contradiction. The witness is minimizing her relationship with the Alberts. She's not being truthful, and she may be biased or have an alternative motive. This is a legitimate impeachment. This is one of the most clearest impeachments I think we have seen this year. Now, the judge had a concern that Jackson had these photos for 6 to 12 months. The Commonwealth never received them, and they may not qualify as pure impeachment. This could have resulted in sanctions, but the judge handled it correctly. The judge limited prejudicial social media evidence, meaning that the judge prevents vacation, drinking, and social media tagging from being shown to the jury, but only to the witness for the impeachment cause. This is the only core relevance. Did she know the family, and did she know the house? The judge protected the jury from improper influence by setting the jury out. No prejudicial material is accidentally shown. Record is clean, and the voir dire determines admissibility. The judge has allowed Jackson to probe the witness credibility. Even though she limited the scope, the judge still allowed the question about the relationship, the question about the house, and the use of the photos for impeachment. There we go, y'all. So what are y'all thinking about this? Are y'all liking this? Do you like this format? Do you want me? I don't know. I need some feedback here. Are we happy with this format? Before I go any further, do you like me breaking it down, or do you just want me to read it? Let me know in comments below. The court. So you're objecting to the argumentative nature that the question began with. Jackson, yes. Court. Okay, you can. I'm not going to say court. I'll just say the lawyers' names. It's just getting a lot. You can't do that with all of the involving. Commonwealth didn't object until now. Oh, you're welcome. You're welcome. You're welcome. Okay, now I got to get my fan on. I'm hot. I'm cold. I'm hot. I'm cold. Okay, so you can't, the court. Okay, you can't do that with all the involving. The Commonwealth didn't object until now, but now they have objected. The argumentative nature of some of these questions and the objection is sustained. But you changed it into impeachment with her with a proper statement, correct? Okay. So if there's a condition objection about the argumentative nature, it would be sustained. If it's strict impeachment, you have to ask the question again. I'll rephrase it, Your Honor. Oh, well, thank you very much. I actually think my mod, June, went through every single word of all of 1,000 pages. I mean, I don't know how many. We got thousands of pages, and she highlighted every objection and only missed one, June. I found one. And then I went through and we've created all of my commentary. So this has been a lot of work, and I'm glad you were enjoying it. Eyes were crossed. Yeah, I bet they were. June, you did a great job. Okay, what's going on with this sidebar? This sidebar is about one thing and one thing only, whether Jackson's question was argumentative rather than impeaching. The triggering question Jackson asked the witness, did you tell Trooper Proctor anything about this officer's questioning my client, correct? This is a loaded question because it assumes the facts yet established, it implies wrongdoing, and it has a confrontational tone. And guys, I'm going to have to get me something to drink in a minute. I'm going to have to take a 2-minute drink because I'm bottle any. That's why Lolly objected. The judge asked what the objection is really about. The judge wants clarity. Are you objecting to the argumentative nature of the question? This is the judge signaling. She sees the question as argumentative, but as a proper impeachment, not a proper impeachment question. Jackson agrees. Yes, it's the objection to the argumentative form. Jackson acknowledges the objection is to the form of the question. This is important because it means the content may still be allowed, but the tone and the structure must change. The judge sustains the objection. The judge explains to the Commonwealth didn't object earlier, but now they have. She will enforce the rule. And that's something else people don't understand. We're watching and we're going, object. And why isn't the judge doing anything? The judge can't do anything until there's objection, even when there should be an objection. She can step in if, or she or he can step in if things get to a certain point that it can cause a mistrial. They can call a sidebar and get things under control. The argumentative nature of some of these questions, the objection is sustained. This is a warning to Jackson. He cannot embed argument, commentary, or insinuation into his question. See, that was the number one problem I felt with Jackson in the first trial, is he was very, very, very argumentative, commentary focused, and insinuated a lot in this first trial. Calmed down a lot, I believe, in the second trial. I need mommy juice. So the judge distinguished between argumentative questions and the impeachment. The judge notes that Jackson did shift the question into impeachment by referring to prior statement. That part is allowed, but the argumentative framing is not. So this is a key legal distinction. Argumentative. I'm going to give you some examples. You didn't tell Trooper Proctor anything, correct? It implies wrongdoing, accuses the witness, and contains embedded argument. Proper impeachment was, isn't it true that your prior statement on blank date, you said X? Neutral tone, direct reference, and no commentary. That is where he should be going. So then we have, is there any continued objections about the argumentative nature? They will be sustained. So he's getting warned. If the strict impeachment, you have to ask the question again, meaning step out of the argument, strip out the commentary, ask it clearly, tie it directly to a previous statement. In other words, do your job. He said, I'll phrase it. That'd be it on that one. All right, let's go to, oh, I think I already did that one. I double did. Because we're on 68. Numbers went backwards. Sorry. Excuse me. Okay, so now we're going to go to page 76. And while we're doing that, give me a second. I'm going to take a quick 5-second, well, not really, however long it takes me to get me some water. I'm going to get up and I'm going to get me some water because I am dying of thirst. Be right back. Oh, that's cold. I have a little ice machine because we have an old refrigerator that doesn't have an ice maker in it because, well, not only is it old, but where it's located, they couldn't get water to it. And so I have one of those water machines you put the bottles in and I have an ice maker on top. Oh, I got brain freeze. All right. Oh, Java Queen, I hope you feel better soon. Ah, that was a whew. So what's your mommy juice? What do you call mommy juice? Let me know. What do you call mommy juice? Oh, my hair looks like crap. Okay, so now we are on page. I need to go page 76. Oh, wait a minute. Okay, that concludes. Let me go to 76 now. Okay, Lally, Mr. Your Honor, may we approach briefly the court? Okay. So my next question, the court, wait until everybody is here. Oh, I'm sorry. So my next question is how she knows. And then this, oh God, this is hard for me to read. And then this sort of gets into the area of not only Mr. Kearney, but this witness also had to visit a visit from the defense investigator, which the defendant was in the car parked outside of her house at the time, that the defense investigator sort of pushed his way into the home with her parents and tried to speak to her at the point during the pendency of this case. Mr. Jackson, Your Honor, that is true. First of all, there was no male defense investigator who has ever approached her. We did actually have an investigator, a female, knock on the door, have a very polite conversation with McLaughlin's parents, who said she would rather not speak with us. And we left, which is our obligation. And well within our, actually, it would be, I understand. So nobody tried to push their way in. I don't know where Lally is getting this other than the witness, and she wasn't even there. We never made contact, court. So I guess I'm a little confused as to you said the next question is going to be what? How she became aware of the name after the fact. I thought she was testified that she saw it in the news, said the court. Jackson, that's what she did say. Lally, again, I don't know. The news is necessarily Channel 5, Channel 4, things of that nature. Hold on, I'm turning on my heated pad. I need my heating pad. The court, you brought it up, and I'm going to let you lead through what do you suggest, Jackson? Oh, whoa. Back it up. Did she just ask Mr. Jackson's advice on this? I don't think this has any, if this is the Commonwealth's way of trying to sully the defendant. Court, no. I'm asking for a suggestion on how you brought it up about she learned the names. Knows these names. She testified to it and the facts that she watched the news. That was on the voir dire. And I think he should be able to lead her and say, well, that's why I asked for suggestion. Mrs. Shack, it is true that you learned this on the news. That was your testimony. And leave it at that. Court, I'm not going to let you get into that Kearney stuff through this witness. There may be other witnesses, but not this witness. You can lead her, and that you can lead her what she learned by the news broadcast. If it was social media news, that's fine. Lally, understood. This is a little interesting in my opinion. Whether the prosecution can introduce highly prejudicial allegations about a supposed defense investigator visiting an online harassment, the Kearney stuff, under the guise of asking how the witness learned of certain names. Let's think about this. Well, first of all, the judge shot it down. Lally tries to open the door to prejudicial allegations. He claims the witness learned certain names, not just from the news, but also because A, the defense investigator visited the home, B, the defendant was allegedly waiting in the car outside, C, the investigator pushed his way into the home, and D, happened during the presidency of the case. Of the case. Y'all, this is extremely inflammatory. If the jury heard this, it would imply the witness intimidation, defense misconduct, and defendant stalking or pursuing the witness. This is why Lally raised it at the sidebar. He knows it's dangerous. He knew that he could be stepping in something. He knew that this could get him in a lot of trouble, including a mistrial. He knew. Jackson immediately corrected the record. Jackson clarifies an investigator was female, not male, polite and knocked. She spoke with the parents. The parents declined. The investigator left. Nobody pushed their way in, and the witness wasn't even present. This direct factual rebuttal. Jackson is protecting the defense team, the defendant, and the integrity of the record. The judge asked, what is the actual question? The judge wants clarification. What exactly are you trying to ask? She's signaling harassment investigator narrative is not coming in, and wants a legitimate question only. This is the real question. Everything else is an attempt to slip the prejudicial context. Hold on. Sorry, my nose. I thought I was going to sneeze. The key is if the witness already answered the question, there's no need to reintroduce. Harassment, defense investigator visits defendant being outside the house. Lally is trying to reopen the door by redefining the news. He's suggesting the news might include the social media and not just the TV. In other words, Adrian Carney trying to get that little tidbit in, and it's not coming in with this witness. This is an attempt to provoke back, to pivot everything back towards the harassment angle. And that is something that they did not get in. And if you notice in the second trial, none of this was brought up in the second trial, as far as I can recall. Now, the judge did ask Jackson how he thinks the question should be handled. She's trying to keep the question fair, avoid prejudice, and stay within the scope of prior testimony. Jackson proposed a narrow, clean question. Is it true that you learned this on the news? And that was your testimony. This is neutral, non-argumentative, consistent with witness prior answer, and free of prejudicial baggage. The judge shuts down all harassment investigator references. I'm not going to let you get into that. The Kearney stuff through this witness. She knew exactly where he was going. She adds, other witnesses may testify about it, but not this one. Lally may only ask about what she learned from the news. Now, if her news, sorry, I'm fixing something before it spills. If her news was the Turtle Boy channel, well, then she could say, oh, I saw it on Turtle Boy. But that's only going to come in if she actually did. He's not going to be able to fish it in. The judge prevented highly prejudicial testimony in this situation. Also, part of this is he immediately corrected the gender of the investigator, the nature of the visit, the fact that nobody pushed inside, and the fact that the witness wasn't present. Jackson did a good job on rebutting that. It really did make a big difference. Let me get to had something I want to say. Okay, this sidebar was very important. The defense investigators pushed into the home. The defendant was in the car and the witness was harassed. The other thing he's trying to do is that this sidebar occurs during the cross-examination of a witness. McLaughlin concerns how she learned certain names, whether the prosecution can introduce the alleged harassment, and whether the prosecution can bring up the defense investigator visiting the home. He wants to raise the issue before asking the next question. Lally claims a witness learned the names through harassment and defense investigator visit. And that just did not fly with the judge. I overdid it on this one. I got to get down to the next. We scroll. Okay, that's not where I want to go. So this particular sidebar really did cause a lot of stir in the legal world, and a lot of the non-lawyering or legal people really, those questions he was asking really went over the heads. Okay, here we go. The next sidebar. I need to do a new sidebar. Anybody got a fun accent that we could use for the new sidebar? I want to do a new one this year. Mr. Lally, so it's hearsay, but it's not for the truth of the matter asserted, Your Honor, but for the state of mind of the witness as far as his treatment and diagnosis and far as receiving, wrong page, receiving the information not in conformity with that he's observing on the patient and then seeking more information. The court. So you have to lay the foundation for that, Lally. I think I did as far as what his observations were, court. Not sufficient, Lally. If I didn't have the statement, I can't ask him. That's weird. My mouse is on this screen and this screen's moving. Oh, that was weird. I don't have the statement. I can't ask him if it comports with what he observed. What did you say, Mr. Yannetti? Well, first of all, I have a question on the relevance of the state of mind as to it pertains to the issue in this trial. And, I think it's just a backdoor way to get some type of hearsay corroboration of Miss Laughlin's testimony, Lally. Corroboration? The jury has already heard from Miss Laughlin. And as to that, what the statements were, we've also already heard those statements are related to two other witnesses separately, the court. So what is it exactly? It's a good time for our lunch break. What is it exactly that you want to ask him? So the judge really doesn't give a shite about the testimony. She's ready for lunch. I want to ask him what he was told as far as the firefighter McLaughlin learned from the person. And why do you say that's not hearsay? Again, the follow-up question I'd like to ask her is whether or not that explanation to him, what the injuries were that he observed, would proportionately with what he was actually observing, or was observing, should have been actually observing. Court, for what purpose, though? Again, I think it goes to his treatment in relation to Mr. O'Keefe and how that was handled. What do you say, Mr. Yannetti? Well, I say that, we haven't received any notice from the witness would be offered as an expert witness. I think there has been a lack of foundation in terms of his qualifications to give an opinion of the status of the injuries and whether they comport with what he was viewing. He's not an expert pathologist, nor has he been qualified with any way. So I would object to on the basis as well, court, isn't this what you all put through another paramedic? Wait, isn't this what you all put in through another paramedic? That I did tell Mr. Jackson he needed to lay a different foundation? Why am I not scrolling here? Oh, wrong page. All right. We will take lunch recess. When we come back, you can argue it to me. Whereupon sidebar concluded. The court jurors, we are trying to let me go down, then they come back. Oh, well, they didn't argue it again. My bad. Okay, let's talk about that real quick. They didn't argue it. They should have argued it, but they didn't argue it. Oh, no, it didn't. Give me a minute. my thing decided to scroll and do its own thing. I don't know what's going on. It just kind of started scrolling. I have to find my spot again. All right. 10, 123. No, 120. What was that through? 121. They're talking about, did someone say she hit him? The defense. Okay, sidebar. Whether the prosecution can introduce hearsay not for the truth of the matter asserted, but for the state of mind, a part of the medical treatment and diagnosis. The judge ultimately rejected this. Let's walk through it. The firefighter paramedic starts to say, someone said she hit him. This is classic hearsay. Out of court statement offered to prove Reed hit him. Defense immediately objects. It's sustained and stricken. You can't do that. That's a no-no. He argues it's not for the truth, it's for the state of mind of the paramedic. It was explained why he treated O'Keefe the way he did. It explains why he sought more information. This is the state of mind of the listener argument. It's sometimes valid, but only when the listener's statement of mind is relevant. The listener's actions are at issue. The statement is necessary to explain those actions. Here, none of those apply. The judge tells Lally, you have to lay a foundation for that, not sufficient. Meaning you can claim the state of mind. You cannot claim state of mind unless you first show paramedics' actions were influenced by state of mind. And those actions matter to the case. The problem is he was working with somebody unconscious, in my humble opinion. Relevant. He wanted to ask whether the hearsay statement she hit him matches the injuries of the paramedic saw. He can't do that. He's not a physician. He's not a forensic pathologist. He has no skills. But what he's trying to say is he treated the patient based off of what he overheard her say. Now, mind you, as a first responder, I have been on scene and I have heard people say, so-and-so did this to them and so-and-so did that. And we look at them and we see a bump and we go, okay, we might need to keep, you treat for the information you receive. Sometimes the injuries underlying, you cannot see them, but you may suspect certain injuries based off the information that you were told on scene, either by the person, but if they're unconscious, bystanders. But in a court of law, it's hearsay. That is exactly what hearsay law forbids. He's trying to use a paramedic to corroborate McLaughlin, suggest the injuries matched being hit by a car, and reinforce prosecution's theory. And that's exactly what he's trying to do. It is a backdoor corroboration, and it stinks. Anytime you go to the back door, it stinks. So, yeah, the paramedic's state of mind is not relevant. The backdoor attempt is to get hearsay in, and it's improperly balusters Mr. Laughlin, and it's cumulative and prejudicial. So he says the jury already heard this statement from Laughlin and from two other witnesses, so it isn't corroboration. This is a very weak argument. That fly is driving me nuts. It's a very weak argument. If the jury already heard it, then it's cumulative, unnecessary, and even less admissible. The judge asked, what exactly do you want to ask? And she wants clarity. He wants the paramedic to say, quote, firefighter McLaughlin told me that someone said she hit him. Double hearsay. And I don't think we talk about that much. Double hearsay in this comment. The firefighter McLaughlin told me that someone told him, for example, that she hit him. It doesn't work. Person, McLaughlin, paramedic, jury. Double hearsay. And it's being offered to suggest the injuries were being hit by a car. Witnesses' statements were consistent with those injuries, and the defendant, therefore, is guilty. Taking my shoes off. I'm getting under my fuzzy blanket. Oh, the blanket y'all got me got coffee on it. It's washing, y'all. I love my blanket. My mods got me. It was so cool. So, The judge asked, why is this not hearsay? Again. And she's giving Lally one last chance to come over here and say, well, Your Honor, it's not because of this. And again, he claims a paramedic needs a statement to understand the injuries. It guides his treatment. That's not true. Paramedics treat what they see, what they can assess, and medically what is necessary, not what's gossip, speculation, or blame statement. Well, I'm going to add to that. Yes, we do sometimes treat or take care of, handle people, or treat what we're told. I'm sitting there and I've got an unconscious patient and I cannot get them to wake up. I do the sternum rub. I do everything. They're non-responsive. And someone in the room says, well, I saw him walking from the bathroom to his bedroom and he had a big bottle of pills. And I don't see bottle of pills anywhere. I don't see any evidence of a bottle of pills. But guess what I'm going to do? I'm going to make sure that I'm going to be thinking, this could be an overdose. Okay. So that can happen in certain situations, but not this one. It's not appropriate here. Yannetti argues a paramedic is not an expert. He can't opine to whether the injuries comport with being hit by a car. He cannot disclose an expert, and he cannot be disclosed as an expert, and he lacks the qualifications. This is devastating objection. It means even if the hearsay came in, the paramedic cannot give the openly Lally opportunity and the opinion that Lally wants. So the judge says this isn't what y'all put in through another paramedic. And she remembers the prosecution tried this earlier, and she told Jackson he needs a different foundation. They still haven't laid it. This is the judge signaling, we've been here before. You still haven't done it right. The sidebar is legally significant because the prosecution tried to sneak in a hearsay statement of mine. The judge caught it. The prosecution tried to use a paramedic as a quasi-expert. The judge blocked it. The prosecution tried to bolster Mr. McLaughlin's testimony. The judge prevented it. The judge is protecting the jury from improper prejudicial evidence. This is exactly what the judge is supposed to do. The defense preserved multiple objections for appeal: hearsay, relevance, expert foundation, cumulative evidence. The sidebar is clean appellate. The sidebar is a clean appellate record. Yep. Now, one thing is that I want to say is I did not have a problem with Judge Cannoni all the time. I had a few problems with her, but not exactly what she said. My problems with her were more how she said things, the tone in which she spoke, the exasperation and the frustration that was evident throughout both trials. That was my issue with Cannoni. All right, another sidebar. Mr. Yannetti, my next and final line of cross-examination will regard to the injuries to his arm that this witness testified about. And the reason I'm approaching sidebars, I would like to show him the autopsy photo that the court has previously seen. I got allergies, y'all. Which depicts the injuries that he's described. Given the sensitive nature of it, I didn't want to display that open court without getting the court's permission first. The court, what does the Commonwealth say? As far as the photograph, I would anticipate something along, speak up. I'm sorry, Lally states, I would anticipate something along the same lines that I would be seeking to introduce at a later time. Court, is this what he saw, though, in the short time in the ambulance? Lally, that I don't know. Yannetti, well, he saw the injuries, whether they had more blood on them or not. These are obviously going to come into evidence. Yannetti, they are. Court, I'm just not sure it is the right witness. Yannetti, well, I want to explore that, Judge. And if I fail to lay the foundation, I will mark them for ID, but I want to show them to him to see if he's willing to identify it. Court, what do you need? Why do you need 3? Yannetti, I don't, court. Okay, I'm going to mark 1 for identification for now. If he adopts it, you can put it in through him. Great, court. If he doesn't adopt it, you can't. I understand. Jackson, please come back. Yannetti, what is the letter for the ID? Court reporter, that will be in for the ID. Court, thank you. Do you intend to put it up in the stream afterwards? Yeti, I would, yes. The court, all right, get him back and adopt it. All right. Once again, we have procedural. So a lot more of these were more procedural than we anticipated in all defense. So Yannetti explains his final line of cross-examination concerns an arm injury of a witness described. He wants to show the witness an autopsy photo depicting those injuries. Because the photo is graphic, he does not want to display it to the jury without permission. This is exactly how careful trial lawyers handle sensitive material and evidence. Now, Lally, he's expected to introduce similar photos later, but he did not confirm whether the witness actually saw the injuries in this condition. Okay? The judge asked a key question. Did this witness see the injuries in this form? He doesn't know. Is this what he saw in the ambulance? Foundation question. This is the question that he's going to say, sir, did you see the injuries of the arm in the ambulance? Yes. Okay. Laid the foundation. A witness could only authenticate a photo if they personally saw the thing depicted in the photo, and the photo fairly and accurately represents what they saw. Lally admits, I don't know, Your Honor. This is a problem for the prosecution. Yannetti says the witness saw injuries, even if they look slightly different, more or less blood. This is a reasonable foundation argument. These are obviously going to come out in evidence, the judge stated, meaning the autopsy photos are admissible. But the question is it correctly admissible through this witness? That is where the judge had an issue. Her concern was that the paramedic may not have seen those injuries in the same condition in the autopsy photos. This is a foundational issue, not an admissibility issue. Yannetti states that he wants to try. If the witness cannot authenticate it, he will simply mark it for identification. This is correct procedure. Now, the judge marks one of the autopsy photos and exhibit N for the identification, allows Yannetti to show the witness privately. If the witness adopts, i.e., says fairly represents what he saw, he can then admit the evidence. If he cannot, it stays marked for identification only. Yannetti says the judge responds all right and gets him to adopt it. It shows the judge protecting the jury from premature exposure of graphic evidence. Autopsies, photos are graphic, emotional, and potentially prejudicial. The judge ensures the jury does not see them unless properly admitted. It enforces proper foundational rules. It preserves the fairness. It shows the judge managing sensitive evidence carefully, and it creates a clean appellate record. There we go. Okay, here's our next sidebar. How are y'all doing? Y'all are pretty quiet in chat over there. It's been 20 minutes since I've seen anybody say anything. Are y'all okay? Have I lost everybody yet? I'm working hard over here. I want to hear your thoughts. This is for all of us to talk about. I am definitely going through this, but ask questions, listen, give me feedback. I'm welcoming it, okay? If you disagree with the judge, tell me I disagree. That's fine. This is interactive. I want it to be that way. Okay, that was 3 drinks for you right there. All right, court jurors, feel free to stretch if you want. The court, Mr. Yannetti, you are all set to put it back up on the screen. Do you have any other questions that you can move on to Mr. Yannetti? Yannetti. Well, I want to refer to the photo when I asked him, but I don't have many questions left. But I did want to use the photo. All right. This is the only area of inquiry? Correct, Yannetti says. Court, jurors, why don't we take a 5-minute recess? All right, court. So when you get cropped, if we could also print a copy of that and exchange it for Mr. Yannetti. Definitely, yeah. Court, what's being produced? Yannetti, I want to print it. Okay. I have kitty. We want to print it so that you can see it before we put it up. That's great. I'm thinking, why didn't you print it earlier? And then we'll swap the exhibits. Court, yes, that makes sense. Yes. Lally, Your Honor, while we're here, I'm sorry, just a reference to what the court has said once before as far exhibit 160. Miss Gilman was able to print it out and reproduce a copy. Okay. But of both run reports for Mr. O'Keefe and Miss Reed? Oh, it's Miss Reed going into the evidence now? Lally, with the next witness, probably. Okay, Lally. I just wanted to give counsel an opportunity to look at them and the court, obviously, before I did that. The court, okay, that's great. So we will swap another exhibit later. We're going to need some time today. I need you to let us know what exhibits you have referred to by number during the court of your questioning, because it really does not make sense to have 308, 309 when they should be 18, 19, and 20. Gosh, I remember this. They had a lot of problems. Hey, Red Panda Power! They had a lot of problems keeping their evidence straight. The second trial, man, it was slick. So I will allow the counsel further questioning to say what was previously marked Exhibit 308 now is Exhibit 17 to do it that way. Okay, Lally. Court, but if you are ready, we will wait until the end of the day, so you will be ready to already intend to refer to the prior exhibits by their numbers. We will do that for today. Lally, okay. Court, okay. All right. So why don't we, is he ready? Okay. Why don't you go over there? All right. We're going to replace. Clerk, actually, wasn't it introduced at 382? Oh, yes. Yannetti, yes, the court. And then it's coming in, but it's M. And then 382, clerk, yes. Gotcha. Court, so we're replacing what's previously marked as identification M and 362 with what I have in my hand. And everybody is agreement to that. Lally, yes, Your Honor. Yannetti, yes, Your Honor. Yannetti, yes, it's 382. Lally, yes, it's 382. Court. That's what I said, didn't I? No, you said 362. Oh, I'm sorry, 382. All right, so this can go back up on the board. Do you all need a copy of minutes? Couple of minutes? Mr. Jackson, we're ready. Court. Paul, did we disrupt that trial for this? Officer, no. All right, so why don't we bring them back? All right, so everybody in agreement? Yes, 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 yes. Court, why don't we deal with Mr. Lally? Why didn't we deal with Mr. Lally? We will replace John O'Keefe's report. I don't remember the number later today. But for now, this is Miss Reed's report. By argument, we will go into evidence, Mr. Jackson. Correct. Court, okay. So we will replace this later. We're going to have to spend a few minutes doing it anyway, Jackson, okay? And for the record, Your Honor, it was Exhibit 160, the court. O'Keefe report, Jim? Clerk, it was Mark G. Identification. Oh, court. Nancy, Whoa. She said she never called the court reporter by her first name. It was a Madam Court Reporter. She just called her Nancy. Oh. She just called her Nancy. She said, I've never called her Nancy. I've always called her Madam Court Reporter. She just called her Nancy. Just saying. How come I don't see some of the other chat like red? Oh, because your chat has to be on all. Do you know what? I didn't either. I'm on top chat too. It needs to be on live chat. If you look at the top left-hand corner, thank you. I didn't even see red panda power. I just saw y'all commenting. It has to be on all chat. Oh, massaging your neck. Oh, can she come and do mine, please? Red panda power. Just FYI. Sometime between now and the new year, I'm going to come see you, and I got you a gift. I got you a gift. Okay, Court, Nancy, do you want Nancy? I can't believe she said her name. Do you want to change this to G for ID to 160 now being replaced with new G for I-60 for the ID and not 160? Everyone in agreement with that? I am so lost. I have no idea. I'm sorry you're getting a migraine, boo. If you don't, you can leave. You don't have to stay in here. Yes. Mr. Netti, yes, I would like to take another exhibit back in the case. What? I'm not going to publish that, but if I want to ask the witness a question about it, what exhibit? The one that we're replacing, the one that was M is identified originally, Mr. Lally and Nettie. What she is asking you about was the run report, not the photograph. The court. Oh, I'm sorry. Oh, yeah. No, we're fine with that. Sorry. Clerk, I do have a question. M has been replaced. Court, yes. Clerk. So what is this? This is the original. So is this also going to be marked for identification? The court reporter. I'm missing a lot of this. Hold on. I feel bad for that court reporter. We need to mark what we are replacing for identification. Court reporter. That would be in for identification of the court. Okay, in for Nancy. You had to do it because the court reporter's name is Nancy. Yes, said the court reporter. So 160 is previously G has now been replaced, and the sticker will go right over the G. Or yes, thank you. Whereas Exhibit 160 is Exhibit G, we're now remarked. The court. No, don't you dare. Court. Then the photograph was replaced, and this is replaced old ones. Where the old one was. Oh my God, I'm going to get out of this. I am no longer going to continue reading this. Court resumes. Thank you very much. Oh, this was a bunch of BS. No wonder they went on forever. So this went through 48. I don't think I need to add commentary for those pages. Do you? Do you think we should just skip through all that? I think we got it. The whole thing was they were very confused about what was when, where, how, and why. Ooh, too far. Oh, no, I need to go back further, I believe. $141 to $148. $197. I thought it went down to 80 something. Did I go out of order? Okay, let me go to 181. I think I accidentally went out of order. Okay, I think this is talking about two different. Hopefully, I haven't gotten these mixed up. So here, Mr. Lally, with that addendum, I'd like to seek to introduce to admit the next exhibit. The court, okay. Reporter Jackson Becker's report, Exhibit 383, whereupon the report of Jackson Becker was entered and marked into Exhibit 183 in evidence. Lally, and Your Honor, with the court's permission, I can return the report to the witness for his testimony. Yes. Okay, that's it. That was a quick little sidebar. Then we are now going to 197, I believe. Yes, page 197. That was a real quick sidebar. I didn't say 19. I said 197. Okay. Mr. Unetti, your permission, I repeat the question. Well, maybe not. We'll go up here. I see you at sidebar, whereupon there was a sidebar conference that follows. Court, so what is your objection, Lally? Your Honor, essentially, counsel is just reading from the report without any sort of indication from the witnesses that his memory is exhausted as to that or what he told. He is reading Trooper Proctor's report, and my cat is going ape shit. Zooming. He is reading Trooper Proctor's report and asking him if he agrees with it. The court, okay, objection is overruled. You can do that, Lally. Thank you. Well, let's talk about that. So this we have seen in other trials, and it is sometimes it's very fine line that they walk when they do this. This sidebar was one narrow evidentiary issue. So like I said, it happens, but it's a fine line. Whether defense counsel Jackson or Unetti is allowed to read from Trooper Proctor's report while questioning a witness who did not write the report. Prosecution objects and the judge overrules. So let's kind of look at that for a minute. The Commonwealth objects to the defense reading of Proctor's report. Mr. Lally argument. Defense is reading directly from Trooper Proctor's report. The witness has not said his memory is exhausted, and the witness has not said he needs the report to refresh recollection. Therefore, counsel should not be reading from the report and ask, do you agree with this? In the classic rule of 612 impeachment procedure objections, Lally is arguing you cannot read from the document unless the witness wrote it, or you're impeaching them with prior inconsistent statements, or you're refreshing the recollection, which requires a foundation. Here, the witness did not write the Proctor report, so Lally is trying to block the defense from using it. Yes, I believe that was frustration sore from point for the judge, and she just wants to keep the trial moving. I can't read that. It's in Twitter. Thank you so much for joining. No one. We are talking. No wonder these sidebars were so long. They were horrible. The judge overruled the objection immediately. The objection was overruled, and you can do that. The judge is saying the defense is allowed to read from Proctor's report. The defense is allowed to ask witnesses whether he agrees with Proctor wrote. The defense does not need to show memory exhaustion. The defense does not need to be refreshed recollection. The permissible cross-examination. This is why, because a lawyer may confront a witness with another person's report, as long as the purpose is for impeachment and not to prove truth of the report. So the judge recognized that the defense was not offering the report as evidence, but they were using it to test the witness's credibility and knowledge. This is allowed under the Massachusetts evidence law, common law impeachment rules, cross-examine rights under the Sixth Amendment. Why the judge allowed it? Well, the judge understood the defense was not trying to admit Proctor's report. Rather, they're using it to ask Trooper Proctor wrote X. Does that match what you observed? A classic impeachment by contradiction. A witness can agree, disagree, or say they don't know, but the defense is entitled to ask. Lally accepts the ruling and he says, thank you. He knows the judge's ruling is final. However, the sidebar is legally significant because it confirms the defense right to use the police reports for impeachment, even if the witness did not write the report. It expands the defense's ability to challenge the witness. The defense can now read directly from the proctor's report, confront the witness with inconsistencies, highlight the contradictions between the officers, and undermine the credibility of the investigation. This is a very powerful point in the testimony and a very big, to my humble opinion, objection to lose. It showed the judge is giving the defense wide latitude on cross. The judge is allowing aggressive impeachment, allowing third-party documents, and not requiring memory exhaustion. This is favorable to the defense. It prevented the Commonwealth from shielding Proctor's statements. Lally tried to block the defense from using Proctor's report. The judge said no, keeping the door open for attack on Proctor's credibility, highlighting investigative failures, and show inconsistencies in the police accounts. So, Mr. Urnetti, Your Honor, my only issue ends with Mr. Lally saying no. Okay, so that's a good breakdown. I could go a lot deeper, but I'm not going to. I think you got the point. 202. We're getting ready to be done with this one, and I will probably end the live at the end of this. We're just over 2 hours. Page 10 gave us a lot of sidebar. Day 10 gave us a ton of sidebar. And we'll go live sometime tomorrow with more mic. Oh, I got to do it. I itch. But we will go through more tomorrow. Okay, I'll try and get documents 7 and 8 lined up for us at the beginning. All righty, Mr. Lally, why did you want to come to sidebar? See, I'm doing it twice, so she gets 2 sips. Why I'm tipping it, I don't know, because I can just... I love this cup. It's an Owala. You can sip straight. They're the SAR. You can pour it in. I love it. All right, Your Honor. Just in regard to scheduling, I know this court. I'm fine to keep going with this next witness, but who will be Lieutenant Gallagher? I remember the court saying that something about sometimes about sometime at the end of today. The court. The jury is never going to mind leaving a few minutes early on a Friday. Is that what you prefer to do, Yannetti? That's perfectly fine, Lally. I think I'd rather be starting with his testimony and court. Okay, so I'm going to let them go now. All you stick around. Ooh, Lally, great. Thank you. The jurors are released. Please discuss everything. Blah, 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 blah. So what I'd like to do is take care of all of these. I know Madam Clerk Reporter has been, hold on, let me back up. All right, since I have decided that it makes more sense the exhibits to be old-fashioned, oh God, we are back to the freaking exhibits. Fashion way, because it's simply not working out. My suggestion is what we'll do is we will have all of the actual been introduced because most, I know, you pre-marked nearly 600 exhibits. They have not been introduced into evidence. So we have numbers 1, 2, 3, 4, 7, 8, 9, 14, 18, and there are additional that are now in the 3 and 200s. So what I'd like to do is take all of these, and I know Madam Clerk Reporter has been great sticking around late during the week to pre-mark things. This is more important to me that we get the record straight from this point. I prefer that the jurors have exhibits in order and not number order, 200, 300, and where they should have be 15, 16. So what I'd like you to all do is to take a look at the exhibits that have actually been introduced, their prior numbers. If you refer to them by their prior numbers, I would permit you for the rest of the trial to previously refer to them as 308, but now Exhibit 15. Unless you feel you don't need to do that anymore, it means things are going to have to be renumbered. And so, Madam Court Reporter, is there anything else we need to discuss or anything else you need from the lawyers, Court Reporter? Just what's the next exhibit number will be. You've got a list of everything. Everything has been introduced. Do you need me to do this, or is this something you all can do, Madam Court Reporter? And I want to come out and make sure it's right. All right. So why don't you ask? I'll take 10 minutes to see if you can work this through. I'm going to go, I'll come out at the end of 10 minutes and see what you have, and we will make sure the record is clear. Does that make sense to everyone, Mr. Lally? It does. The only thing I would like to ask and to add is that, Your Honor, it is in conformity with the court's ruling as for with action, the run the sheet and run reports. I'm not sure if they've been stickered or not, but they are medical records with regards to both the defendant and the victim would be in there. And I would ask for them to either be marked as identification or taken out at this point. Mr. McLaughlin indicated that they haven't been marked yet, so I would just ask to sort of retrieve them. The court, all right. So that's sort of second point. I assume are many, many, many pages of medical records. And one of the things I told you this morning is if records are going to be introduced subject to redactions, those redactions have to be done before they're introduced. It's going to take some time. So you have to be, if you're not in agreement, then you will need to tell me, and you're not in agreement over, I will have to decide. But they need to be redacted beforehand just because of the long trial. I do not want to take any longer than necessary has been. And we have to make sure all the exhibits are ordered, especially if they're going to end up in numbering in the hundreds. All right. So factor into your schedule. We've got many days that we won't be in session. It seems like a good use of counsel's time to redact records and talk. If you need additional time, you need to cut into the evidence. I prefer not to, but I need to know. All right. I have received from the Commonwealth all of the videos I requested. I've received flash drives today. When I get the videos, I thought I was clear yesterday. Apparently I wasn't. So when I can get all of the videos that the defendant intends to introduce, whoops, the defense didn't turn over all their videos. I had hoped to look at them over the weekend. Mr. Jackson, we can do. It's not a matter of getting them onto a flash drive. That's quick. It's just a matter of getting them to the court. So I would invite the court to direct us how, if you want to use them this weekend, to let us know. We work on Saturdays and Sundays. The court, so you can't do it today? You can't do it before you leave? Your IT guy, I might be able to, court, if you can do it before you leave. If you can just download it to a flash drive, that would be, do you want to go talk to him? Yannetti, he might be able to do it, Mr. Jackson. We'll be able to do that. Why don't you talk to him? Whereupon, brief pause. Yes, we won't leave until it's given to you, court. That would be great. And Mr. Yannetti, yesterday, did you say you'd also give me some ideas onto why you think they're coming in? Sure. The court, okay. If you have that, that would be great, Yannetti. Yes, all right, court. Little. I just want to be sure if I'm very clear about what the court would like. She reminds me of a little dumb blonde. I don't know. She's not a dumb blonde. That girl's smart as a whip. I'm just playing. It's 11:30 p.m. I need to get done with this. We provided a double video, the one that we had put in Google, Good and Soft's camera together. The court wants every single video that we intend to produce. Yeah, little. For the rest of the trial. Yes. Okay, understood. All right. And is what I requested from both of you I received? Come in, tell me if I'm wrong. Mr. Dermont handed me a flash drive today that said this was all of the Commonwealth's video exhibits. Little. And that was after we met this morning, correct? Yes, literally. Okay. Court. All right. So that will be great. And I want to know what's on them. This was surprise yesterday, and I shouldn't be surprised. Understood, Yannetti. Court. Okay. I'll come out after you have marked the exhibits. Do you need a break before Madam Court Reporter? No, Your Honor. And we're done. I think this is the end of document 10. Let me go through just to make sure. It is. We're done with documento 10. We finished with 10. All right. I don't think we need to go through all that. I think we know exactly what happened there. It's again all about the evidence and about all of the. It's all about that base. No, kidding. It's all about a lot of evidence and the fact that they can't keep their stuff straight. I don't understand how it got so mixed up, but you never know. It's Canoni Court. And I'm not trying to be mean, but Miss Canoni, my hair. It looks weird. There we go. Anyway, Miss Canoni obviously has an attitude a lot of times, and I understand she's exasperated. She's tired. She's exhausted. She's just impatient with everybody. It's her personality, maybe. I don't know. But I will say I do miss that woman who pretended to be Judge Canoni, and she did a comedy routine on her daily during the trial. Absolutely adored her. I really did. Adore her. Where's G's? Oh, G4. So anyway, we're going to stop here. I've been live for over 2 hours reading, and it's getting a little bit cross-eyed. Again, June, thank you so much for these documents. You are fabulous. Really appreciate all that you've done. Andrea, Angela, I hope your headache gets better. No. I know. Everybody who's new to my channel, if you've never been here before, welcome. If you've been here before, thank you for coming back. We will go live again tomorrow. Again, I don't know. I've got a lot to do. In fact, I'm going to go clean a fully blown, messed up kitchen tonight. I'll probably be cleaning for a couple of hours. And then I've got my sister, that lady still has not come and picked up all that furniture, and I'm trying to nail her butt down tomorrow. We got my dad home. He's home. He got out of rehab. He's home. For those who don't know, my dad almost went to the pearly gates. He had a blockage in his small intestine that was so bad that he could have possibly not been here. He turns 91 on the 28th. He's getting ready to have a happy birthday. And last year we did a big 90th birthday party. So we're so excited to have him around another year. I tell people all the time, I have an agreement with God that he's going to be here for 100 years. God may not agree with me, but I'm agreeing with him. Yeah. So, Daddy is home, 91 years, almost 91 years old, and his mind is sharp as a tack. And I can tell you what, when that guy when I walked in the room yesterday and he goes, got a job? You looking for a job? I'm looking for a job, Papa. I'm looking for a job. I just graduated, for those who don't know. A week ago, I graduated with a degree in criminal justice. Don't feel any different. I just feel like I have a little more authority in what I say. Maybe someone challenges me, I can tell them to eat dust. But other than that, I am job seeking. So keep me in prayers for that. So anyway, we will see you tomorrow sometime. Keep an eye out. Remember to click that bell so you know when I go live. Over the Christmas holidays, we are not going live every day. When I get a job, things are going to change, but I'm still going to be doing this. So y'all just grab a hold of this sleigh and let's go for a ride and see where we end up. Until then, I will see you tomorrow again. Mods, you are fabulous and I love you. See you. Thanks for watching. Please comment, like, share, and most importantly, subscribe. I hope you have an awesome day. Till next time.